Ladies and gentlemen of the jury, we're going to take our lunch break. Well, yeah, we know. We're going to take your lunch break early now. You are. We're going to stay and do some legal matters with attorneys tonight in the courtroom. So just keep my admonition in mind about forming an opinion about the case, talking about the case, doing research. Just be back in time so that we can start hopefully about 1:30 now. That in mind?
All rise for the jury.
First order of business.
Mr. Brown, was there anything you needed to put on the record, or did you want us to talk with your client?
I have with her, but I don't think I have anything to put on her.
All right,
I was just going to ask that she be released from her subpoena so she can go. No? Kate?
Release her from transport. She can go today, but not from
Oh,
the subpoena.
okay. Sorry.
Release for today. If we need her back, I'll have the state and Mr. Facemire coordinate with you again. Fair enough?
Yes,
Thank you. All right, so I believe we have Mr. Scott Williams on the line, who is Mr. Ellis's attorney. Is that correct, counsel?
Yes, Your Honor.
All right, can we put him in the room?
Yes.
And Judge, we are asking for the prison to bring Kevin into the courtroom.
All right. Is he on another floor?
Yeah.
All right, so it's going to take a moment to get him down. Mr. Williams, good morning. Thank you for working around our schedule today. I know you've been in trial.
You're welcome. Thank you, Your Honor. Good to see everyone.
We got some feedback. Just a second. Could you say something again so we got feedback from you still?
Good morning.
Good morning. That's much better. They're bringing your client down from another floor, so it'll take just a moment or two, and then we'll bring him right in.
Thank you.
Thank you.
Just one moment, Judge.
That's fine.
It's going to take a moment because we can't have them cross paths.
So, isn't she locked up in this holding cell?
Yes, but Mr. Brown is talking to her right now. So
Well, they can't bring Kevin down and bring him straight in.
we're just keeping them separate so that they don't have the ability to talk to each other.
So,
We have deputies coming to do this. It's just taking a moment.
all right. Why don't we do this, counsel? Let's just take a brief recess, Mr. Facemire, so it's not everybody here. Probably about 5 minutes to get him down, and then I'll come back in as soon as I get your client. Did you hear what the problem was?
Yes, Judge.
I'm asking Scott, Mr. Scott Williams. Did you hear what the problem was?
I did, yes.
All right. So let's take that brief recess, and then when you've got Mr. Thank you. Please be seated. Let's go back to the regular matter of State versus Tracey Grist, 241101170. Ellis, I'm going to have them put you over in the jury box there. All right, Mr. Williams, as you probably just gathered, your client is present in the courtroom. He's sitting in the jury box right now. I'll turn the time over to the state and then to you, and then Mr. Facemire, if you have anything you wish to put on the record. Who's taking over for the state? Mr. Pomeroy.
I'll take this one, Judge. Thank you. Your Honor, as the court knows, Mr. Ellis was a named co-defendant of Ms. Grist. He has already had his trial where he was convicted. The state would be interested in calling Mr. Ellis in this case. However, we have been informed by Mr. Williams' attorney that Mr. Ellis will assert his Fifth Amendment privilege and to not testify in this case. We previously discussed in motion work, specifically citing Mangrum and Benson on Utah Evidence Rule 804, that a valid claim of privilege by a privilege holder or a representative on his or her behalf is sufficient to establish unavailability. So the main reason we are here today, Judge, is I believe we can have Mr. Williams assert the privilege on Mr. Ellis's behalf. He can make whatever proffer he wishes to make about that. I do suggest that we have the benefit of the record here, and the court then just simply ask Mr. Ellis if that's accurate, that he intends to assert the privilege Mr. Williams will assert on his behalf.
Mr. Williams?
That's correct, Your Honor. I've informed Mr. Ellis of his rights. He is currently perfected a notice of appeal. In his particular case, I believe he clearly has a Fifth Amendment right that he can assert. And consistent with my advice, it is his intention to assert that Fifth Amendment right in blanket fashion. He would assert that to any question asked of him by the prosecution or any other attorney in this proceeding.
Thank you. Is that good? Is the state offering any immunity, or Mr. Pomeroy?
The state is not offering immunity, Your Honor, but for the record, it's my understanding that in the hypothetical case that were we to offer that immunity, Mr. Ellis would still elect to not testify even if the court ordered him to do so. And I believe, again, that Mr. Williams could proffer that.
Mr. Williams?
I believe that would be the case. I appreciate and agree, however, with the state that is the invocation of his Fifth Amendment right does not require them to then provide immunity and subject him to the potential penalty that might be associated with a contempt finding, and that we are not to that stage, and appreciate not having to get to that stage. But were they to provide immunity, yes, my understanding is, now this would not be related to my advice, of course, but that he would not answer questions anyway.
All right, thank you. And Mr. Ellis, do you wish to abide by your client's, or excuse me, your attorney's advice and assert your Fifth Amendment rights?
Yes, I do.
All right, thank you. All right, the record reflects Mr. Ellis is asserting his Fifth Amendment rights as advised by his counsel. Anything else you wish to put on the record, Mr. Pomeroy?
We're good for now, Judge. Thank you.
All right, Mr. Facemire, anything on behalf of the defense you wish to put on the record?
Nothing, Judge.
All right, thank you. All right, thank you, gentlemen.
Thank you.
All right, anything else we should discuss before we recess for lunch today?
Can I approach?
Can I be excused?
Yes, I'm sorry. Thank you, Mr. Williams. Have a good day.
Thank you.
Yes, counsel, come forward.
Yeah, that's you after.
All right, Mr. Pomeroy.
Thank you, Your Honor. As the court knows, we previously filed a motion to admit certain evidence subject to Rule 804 for when a witness is unavailable. We're asking the court now, based off of the invocation of privilege, to find that Mr. Ellis has asserted his Fifth Amendment privilege, and Mr. Ellis is now an unavailable witness pursuant to that rule and its exceptions.
Thank you. Mr. Facemire, anything from the defense?
Nothing, Your Honor. It's been briefed and discussed and anticipated how it would go as outside.
All right, thank you. All right, so as the court had discussed with the parties in chambers on the first day of trial, with us moving to this point today, I will find that the defendant is an unavailable witness based upon his exercising of his Fifth Amendment rights in totality. I think there's a few cases that allow us to move forward with the proposed testimony or the recording that we're going to use that I've referenced. And also getting to that point is U.S. versus Small 605 F3D 765, and then Salt Lake City versus Rocky Chad Williams, that's 2005 Utah Act 493, discussing the use of these out-of-court statements that were made by Mr. Ellis. So with that in mind, that'll be the order of the court. There won't be a written ruling as much as we're in the middle of the trial. I think it's pretty clear where we are at this point. Anything else, Mr. Pomeroy?
Could we please release Mr. Ellis from his subpoena?
Any objection, Mr. Facemire?
No objection.
All right, so Mr. Ellis will be released from his subpoena as well. Anything else we need to put on the record before we take our lunch break, gentlemen?
No, Judge.
All right, Mr. Facemire, anything else from you for the record?
I necessary.
Anything else you need to put on the record before we
No,
take
Your
a
Honor,
lunch
thank
break?
I'm good.
All right. The doors will be open about 1:15. I'll see everybody back just before then with the goal of starting at 1:30. We're in recess.
All right.